Okay, question 748. Is the unlicensed practice of real estate a first-degree misdemeanor, a second-degree misdemeanor, or a third-degree felony? Answer: the unlicensed practice of real estate is a third-degree felony. Question 749. What type of damages will the recovery fund cover? Answer: the recovery fund only reimburses compensatory damages, which are actual monetary damages awarded to the claimant. It does not include attorney's fees, court costs, punitive damage, or treble damages. Question 750. If the recovery fund pays compensatory damages to a claimant, what will happen to the licensee? The answer: the offending licensee will automatically have their license suspended. Their license is suspended until they can repay the amount paid by the recovery fund plus interest. Question 751. What is the maximum payout from recovery fund for one incident? Answer: $50,000. Question 752. What is the maximum payout for any one broker or associate from the recovery fund in total over time? Answer: claims against one real estate licensee, maximum is $150,000. Question 753. If a broker who complies with an EDO is later sued, the fund can reimburse for what amount? Answer: up to $50,000. Question 754. In regards to question 753, if the case involves compliance with an EDO, the recovery fund will not only pay compensatory damages, they will also pay for what? The answer is the broker defendant's reasonable attorney fees and costs, the plaintiff's reasonable attorney fees and court costs if they win. Okay, question 755. Does the Fair Housing Act apply to commercial transactions? The answer is no. It does not cover non-dwelling buildings, although this could be negated if there is a licensed real estate agent involved. Question 756. To be exempt from the Fair Housing Act, how many homes can an owner own? The answer is 3 or less. Question 757. An owner is exempt if a rental has no more than how many units? The answer is 4. An owner must reside in one of them also. Question 758. Who enforces the Federal Fair Housing Act? The answer is HUD. Question 759. Can HUD investigate if no complaint has been filed? The answer is yes. Question 760. How long do you have to file a complaint with HUD? The answer is 1 year. Question 761. If they feel they have been wronged in a Fair Housing Act, how long does someone have to go to civil court? The answer is 2 years. Question 762. What is an injunction? The answer: an injunction is a court order that either stops an individual or entity from doing something or tells them they need to start doing something, usually until the outcome of a judicial proceeding is decided. Question 763. After what year do buildings have to abide by the Americans with Disability Act? The answer: the Americans with Disability Act, ADA, requires that public accommodations in commercial facilities that are newly constructed, built after 1993, be accessible. The answer is 1993. Question 764. What kinds of properties does the Americans with Disability Act deal with? The answer is the Fair Housing Act applies to residential dwellings. The ADA applies to employment, public accommodations, and commercial facilities, public transportation, and telecommunications. Question 765. What is the Interstate Land Sales Full Disclosure Act? The answer is the law requires developers engaged in the interstate sale or leasing of 100 or more lots to file a statement of record and register the subdivision with the Consumer Financial Protection Bureau. Question 766. If the lot being purchased is subject to jurisdiction of the Interstate Land Sales Full Disclosure Act, the contract or purchase agreement must inform buyers of their rights under the Act. How long is the cooling off period? Answer: the buyer has until midnight of the 7th day after signing the contract to cancel. Question 767. If the developer of 25 plus lots does not give the buyer a copy of the current property report before the buyer signs a contract, the buyer has up to how many days, or years, to cancel the contract and get their money back? The answer is 2 years. Sorry, I said days. Question 768. Under the Interstate Land Sales Full Disclosure Act, developers of how many lots must provide the prospective purchaser with a property report before they sign the contract? The answer is 25 or more lots. Question 769. Landlords who rent 5 or more individual dwelling units must give written notice to the tenant about how they are holding the funds, either in the lease agreement or within how many days after receipt of a security deposit or advance rent. The answer is they have 30 days. If the landlord does not intend to oppose a claim on the security deposit, the landlord has how many days to return the deposit? The answer, 15. Question 771. If the landlord does intend to impose a claim on the security deposit, the landlord has how many days to give tenant written notice by certified mail to the tenant's last known mailing address of their intention to oppose a claim on the deposit? The answer is 30 days. Question 772. How many days does the tenant have to file an objection to landlord's claim on deposit? Answer, 15 days. Question 773. The tenant may terminate the rental agreement if the tenant delivers written notice specifying the landlord's noncompliance with the lease and indicating their intention to terminate, and the landlord then fails to comply with the rental agreement within blank days. The answer is the landlord must comply within 7 days. Question 774. What is accretion? The answer, accretion is the process that results in the gradual increase in land area through deposits of soil by natural forces. What is reliction? Answer, reliction is a gradual increase in land area when water gradually withdraws. Question 776. What is severance in regards to personal property? The answer, severance is the act of converting real property into personal property. Question 777. What do tenants in common have? Answer, undivided interest in the property, the right of inheritance instead of survivorship, and the ability to own unequal shares of the property. Question 778. What are the characteristics of joint tenancy? The answer, it requires all 4 unities, usually comes with the right of survivorship. If one owner dies, the other owners inherit the property, not the owner's heirs. The owners always have equal shares. And if a joint tenant dies, their share is inherited by the surviving tenants. If they sell their share while still alive, the new owner becomes a tenant in common. 779. Joint tenancy differs from tenancy in common in 2 ways. What are they? The answer, in joint tenancy, the interests of the parties are always equal, and also in joint tenancy, it includes the right of survivorship. Question 780. What is the right of survivorship? The answer, it's the statutory principle of survivorship tenancy that provides that when one co-owner dies, their ownership interest reverts to the surviving co-owners. Question 781. What is a fee simple defeasible estate? The answer, it's an estate characterized by perpetual ownership on the condition that the property is used for a certain purpose under specific conditions. Ownership reverts back to the original owner if these stipulations are violated, but the condition runs with the land. Question 782. What is a fee simple determinable estate? The answer, a fee simple determinable estate is a type of fee simple defeasible estate which causes the title to automatically revert to the original owner if the deed requirements regarding property use are violated. The estate will come to an end automatically and immediately upon the occurrence of a designated event. No legal action is required of the grantor in order to assume recovery of this kind of state. 783. What is a fee simple condition subsequent estate? The answer, this is the same as a determinable estate in that it comes with a specific requirements or conditions. The difference is, for ownership to change, the grantor of the estate must prove in court that the defeasible fee estate condition has been violated. Question 784. What is an absolute estate? The answer: it's an estate without restrictions that is freely given to heirs. This is the most common type of residential real estate. This is also called a fee title estate. Question 785. What is a reversionary estate? Answer: it is when the person giving the life estate, the grantor, wants it back when the person with the measuring life dies. Question 786. What is a remainder interest? The answer: a remainder interest is when the person granting the life estate doesn't want the estate back when the person with the measuring life dies. Instead, they want the estate to pass to someone else, who would be the remainder man. Question 787. What is pure atra vie life estate? Answer: pure atra vie, the person with the life estate and the measuring life are two different people. Question 788. How big can your lot be to qualify for a homestead exemption? Half an acre in the city and 160 acres outside the city. Question 789. What is an estate for years? The answer: a lease with a specific starting and ending date, also known as a tenancy for years. Question 790. What is a tenancy at will? The answer: a tenant's occupancy of a property with the landlord's consent. Question 791. How long is the cancellation period on a new condo? The answer: 15 days. Question 792. How long does the buyer of a new co-op have to cancel? The answer: 15 days. Question 793. How long does a buyer of a used condo have to cancel? Answer: 3 days. Question 794. Do you need a license to sell timeshares? Answer: typically yes, unless you are a salaried employee. In that case, it would be no, period. Question 795. Where condos are concerned, what is the declaration? The answer: it's the legal document that, once filed, creates a condominium. In Florida, one of the required documents, period. Question 796. What is a proprietary lease? The answer: a long-term and exclusive lease given to a resident and stock owner of a cooperative unit. Question 797. Where condos are concerned, what is the prospectus? Answer: a prospectus is a document prepared by a developer that summarizes what is in the condominium documents required for condos with more than 20 units in Florida. Question 798. With respect to real estate, what is alienation? The answer is the transfer of ownership to real property. It may be voluntary or involuntary. Question 799. What's in the granting clause? The answer: the granting clause is a section of a deed identifying the property to be conveyed. The grantor, the grantee, and the grantor's promise to transfer title to the grantee. It is also called words of conveyance, and it is needed for a deed to be valid. Question 800. What is the habendum clause? The answer: the habendum clause is a necessary clause within a deed that clarifies the type and extent of interest conveyed by the granting clause. It serves the purpose of defining or limiting the ownership interest of the grantee, such as fee simple, defeasible fee, or life estate interest. A habendum clause should follow the granting clause, and its provisions must agree with those set down in the granting clause. Question 801. Who needs to be present in the signing and recording of a deed? The answer: for a deed to be recorded, the state of Florida requires the grantor to sign the deed in the presence of 2 witnesses.